Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Baker Botts Enforcement Insider, a podcast covering the latest trends and developments in compliance and enforcement with a focus on the energy and technology industries. I am Michael Loesch in Washington, D.C., and with me today, as always, is Brendan Quigley from New York. Hello, Brendan.
Hey, Michael. How are you?
Good. So what are we into today?
Today, we want to talk about two CFTC topics that we've seen as kind of consistent, regular, reoccurring issues across the CFTC enforcement program. And that's one, kind of the substantive issue, cross-market manipulation, and two, what I would say is more of a procedural issue, which is cooperation credit in investigations. And those issues were raised recently in the same case, a recent CFTC resolution involving TotalEnergies trading.
Right.
So in late August, the CFTC announced a significant settled enforcement action against TotalEnergies for violations of the Commodity Exchange Act and CFTC rules implemented thereunder. And the case concerned attempted manipulation in the European gasoline markets. And as alleged by the CFTC, this conduct constituted attempted market manipulation in violation of Section 61 of the CEA and CFTC Regulation 180.1A1. And as a result, TotalEnergies is required to pay $48 million in civil monetary penalties and to cease and desist from violations of the CEA and CFTC regulations. So, Michael, let's take a look at the core allegations in this case.
Yeah, sure. So, look, this is an attempted manipulation case, and at its core, it is a cross-market manipulation case, right? Where the company's activity in the physical Eurobob markets was allegedly intended to manipulate the regulated futures contracts that are linked to the physical European gasoline markets. So just a tiny bit of background. I know most of you listening should be familiar with this, but Eurobob is a type of refined gasoline used primarily in Europe, and companies both blend and sell Eurobob, and there are futures contracts that are linked to the physical markets, and the value of the futures contracts is determined based on a benchmark price for physical Eurobob that's published by Argus, and that's the Argus EBOB benchmark. And so the Argus benchmark is based on brokered physical transactions that are reported to Argus. So again, it's a cross-market manipulation case. It's also a benchmark case, which is something that the commission has been focused on for some time as well. And according to the settlement order, the company attempted to manipulate the futures contracts through its physical market trading. Specifically, the company sold Eurobob in the Argus brokered market at prices that were below what other buyers indicated that they would be willing to pay. And during the period at issue, the company sold more physical contracts than it had sold in any other previous month. So there was a high volume of trading during the month at issue in the physical markets. And the company's trading was a significant percentage of the marketplace. So the allegations are that it was more than 60% of the volume that was transacted during the window. So the company's sales were reported to Argus, and they were incorporated into the Argus EBOB benchmark. So all that's fine, but the allegation goes on to say at the same time that the company maintained a large short position in the EBOB-linked futures contracts, which would benefit in value from a decline in the reported price on the Argus benchmark. So this case alleges that the company attempted to benefit its short futures position by selling large quantities of the physical product at prices that were lower than what buyers indicated they were willing to pay at prices that were uneconomic. The allegations include certain specific circumstances where specific traders maintained an offer to sell at a price that was lower than another market participant's indicative bid. And the commission claims that the company was willing to accept this lower price and less revenue from the physical trading activity in an attempt to depress the reported price and depress the Argus benchmark, which would boost its short positions. So all taken together, the allegation is that the conduct constituted market manipulation. There's a lot packed in there, and we're going to try and unpack some of that. But Brendan, do you have any thoughts while I pause there?
Yeah, just looking at the order, one of the key pieces of evidence that CFTC relied on is WhatsApp communications between and among the different traders and between the traders and brokers. These communications reflected that company traders refused to sell at higher prices that others are willing to pay, and instead insisted on lower prices. And the CFTC alleged that those were, as you said before, uneconomic prices.
Yeah. I mean, these cases revolve around communications, right? Key communications. So that is an area of training for personnel that needs to be a focus, right? That to be fair and accurate and thoughtful in your communications so they can't be used against you in an inappropriate way. So let's talk about some of the other key takeaways. So taking action in one market to obtain an advantage in a different but related market is going to be considered manipulation by the commission, and is something that the CFTC has been, focused on for the last decade. And so if you have trading activity in the futures markets and are also trading in the underlying physical, you need to be very focused on that trading and the potential perception that the activity in one market is intended to influence the price in another market. Some other things that the commission highlighted in this case include that the physical trading in the Eurobob market was a departure from its standard or historical pattern. Right. They traded during this month more than they had in any prior month, and they used that fact to support attempted manipulation. So that's another issue that from a compliance standpoint, you should always be focused on, right? Anytime you're departing from a standard pattern, unusually large physical sales or different pricing or new products or different trading strategies or an increase in the market volume, all those things should be flags that you're focused on. And if there's a change in your trading pattern, consider whether there's a need to document the change and the basis for it contemporaneously. Another thing that I think is worth discussing in this case is price reporting, right? Anytime you are reporting prices to a reporting agency for inclusion within a benchmark, when you're trading within that respective trading window, you have to understand that there's risk associated with that, and your monitoring, surveillance, internal controls all need to be heightened for that type of activity. Here, the physical trades at issue were reported to Argus for benchmark calculations, and that was part of the allegation. Anything on any of that, Brendan, you want to jump in on?
So yeah, Michael, I think you hit the key points. I mean, just keeping track of these red flags. I mean, we've seen this in a number of cases, and I think this was in the, we'll talk about this when we talk about the consenting statement in a second. But unfortunately, sometimes prosecutors and regulators, when you have a hammer, everything looks like a nail. And some of these indicia in the, that they cited, such as aggressive pricing, unusually large physical sales in different markets, what could be characterized, potentially as legitimate hedging activity or other legitimate activity. Once the investigation gets rolling, it's sometimes, unfortunately, going to be judged with that hindsight. Again, kind of confirmatory bias we deal with a lot. So whether it's SEC, CFTC, DOJ, if you're being cognizant of those red flags or potentially yellow flags as you're engaging in these transactions and documenting the kind of the business rationale.
Absolutely. And another thing we haven't touched on yet that I think is acknowledging and noting for participants in this market is the legal standard for manipulation that is reflected in this settlement order. So the commission in the order states that Section 6C1 and Regulation 180.1, relevant provisions here, that they do not require the showing of an intent to affect prices or an actual effect on prices, nor do they require a showing of reliance or harm to market participants. So that's a pretty broad standard. And they go on to say that the commission must only show that the intentional or reckless employment of a manipulative device, scheme, or order in connection with any swap or contract or sale for a commodity. This is a pretty broad interpretation, the continuation of the commission's use of the Dodd-Frank fraud-based manipulation standard, untethered to prices or market harm. Of note is that this theory is generally untested in court. And if you look at the order closely, you can see there are a number of cites to this legal interpretation that I just went through, and they are all to consent orders as opposed to cases that resulted in litigation or from litigation. So this is the continuing evolution of the standards in this area. And it's important to keep in mind that the commission believes that it doesn't have to show an effect on price or market harm, and that it can even rely on reckless use of a manipulative device or scheme to prove up a manipulation case. So we'll see how this continues to play out in cases, and at some point there may be some additional litigation on this, but as there was with respect to other provisions, particularly under the DRW case, but time will tell. And then the theory is, again, cross-market manipulation, right? It relies solely on trading in the physical markets while the company held a related position in the financial markets. And it does not take into account any of the specifics of the underlying physical markets and trading activity there, including here with respect to these physical markets where the quotes are indicative, which is relevant here and sort of just glossed over by the commission. So Brendan, let's move on to another interesting part of this, which is the separate statement from Commissioner Pham.
Sure. So Commissioner Pham issued a separate dissenting statement declaring her opposition or objection to the alleged attempted manipulation charges. She noted the lack of evidence. She called it flimsy, speculative, and circumstantial. And she noted that the CFTC failed to take into account the substantial evidence of market conditions of fundamental evidence of market conditions and fundamental supply and demand drivers. I also think it's interesting, Michael, I know you'll get to this. One of the things we see in our practice, and again, practicing with DOJ, SEC, and CFTC, is the importance of white papers and pre-submissions, whatever they're called, and before the particular agency that you're dealing with. And she made the point that the CFTC, the commission, didn't have the benefit of one of these white papers in making its charging decisions. At least that's what she said in her statement.
Yeah, that's, if true, particularly troubling for anybody who's beginning the path on investigation and trying to resolve one. So this was a pretty intense dissenting statement from Commissioner Pham with some serious concerns expressed. I mean, she also talked about, in addition to those sort of internal administrative failures, just talked about the impact that an action like this can have on the ability of commercial end users to use derivatives to hedge and to manage the risks of their business in volatile markets. So to quote her statement, this case is a textbook example of policymakers with no industry experience second-guessing commercial business decisions in a bubble. So pretty strong words from Commissioner Pham, but of note, but of no practical consequence in this matter because the matter passed and the settlement went forward. So ultimately, the settlement involved, as we said at the outset, $48 million penalty, cease and desist order. There were no specific remedial undertakings in this matter. It was settled on a neither admit nor deny basis, so it didn't require admission. So this was basically a significant penalty case in terms of resolution. There's one other interesting thing to talk about, Brendan. Do you want to touch on that?
Yeah, sure. So the CFTC's order included an acknowledgement that the TotalEnergies had provided, quote, some, unquote, cooperation to the investigation. This is something we've seen in DOJ settlements recently as well, where there's a discussion of the cooperation provided by the entity. And even if the entity does not get, quote unquote, full cooperation credit, they get a partial credit. And the interesting thing about these is that they outline at a high level what the company did or did not do to get that credit. So here, the order noted that the company had facilitated voluntary witness interviews with former employees, voluntarily produced large volumes of documents, and flagged to the CFTC potentially relevant documents. However, the CFTC also noted that the company did not produce, at least timely produce, certain requests and WhatsApp communications, did not adequately preserve those communications after the division's request, the enforcement division's request. And there was other potentially relevant evidence that not defined in the order that was not available to the CFTC. And these are always useful, sort of checklists, and you kind of aggregate these, which we tend to do in terms of what the expectations are of the regulators, in terms of what a company will produce, what it will do, and what the regulators will A, look favorably on, and B, kind of expect in terms of here, for example, flagging the CFTC potentially relevant documents. Sometimes clients don't want me to say, oh, well, why are you highlighting the key documents? But here is a good example of them, incentivizing that behavior and saying, at least at some level, it got them some favorable treatment.
And on the flip side of that, failure to promptly produce documents and not adequately preserving requested documents was noted as a failure and a lack of cooperation. So, we can talk about I think in another podcast, the WhatsApp communication angle and the commission's focus on the broad range of electronic communications potentially used in a business and the obligations to preserve those. But based on the channel communications cases and as sort of reinforced by this, it's definitely something that from a compliance perspective, every company, corporate end users, commercial end users and entities should be thinking about how they manage their communications and what policies are in place with respect to those. I do also want to highlight one other CFTC enforcement matter that addresses the issue of what constitutes self-reporting. In a matter from back in August of this year, the CFTC entered into a settlement in the matter of a company called Raisin. It might be pronounced differently than that, but it's Raizen, could be Heisen. But in that case, the company agreed to settle for $750,000 for allegations related to wash trading. Now, that's an interesting case for a number of reasons, but with respect to self-reporting, it's interesting because the commission did not credit the company's self-reporting of the wash trading conduct because it was not done promptly. There was no recognition for self-reporting in the settlement order, but the lack of that credit was actually raised in a separate statement by Commissioner Pham, who indicated that the company self-reported the trading to the CFTC 6 months after it occurred and after the company had conducted an internal review. And the staff did not credit that self-reporting because it was not done, quote unquote, promptly as required by the Enforcement Division guidance for self-reporting. Now, I think this is really important. Companies often struggle, Brandon, with when to self-report and under what circumstances to self-report and how to self-report. And there's no definition of the word prompt in the CFTC's guidance, so it's actually vague. And so one takeaway from this case is that at least it puts down a marker for market participants that waiting 6 months to self-report may not get you any credit for self-reporting. I think it's also worth noting that Commissioner Pham, at least, was critical of the commission's approach in this matter. And in her view, the commission should be welcoming corporate internal investigations and reviews of suspect conduct. And the commission should be willing to credit the company for self-reporting if the company reports after the conclusion of an inquiry, which does seem to make sense. So when does the clock start? Clearly, the commission currently believes that the clock starts from the time of the conduct. So you need to be thinking about self-reporting, as soon as the conduct occurs. And that's all important stuff to know for market participants as they think about these issues. So, Brendan, anything on that from you?
No, I think, look, I think this emphasizes the importance of kind of internal reporting systems and things like that to make sure you get the information. To the extent that you can get it up the chain, as fast as possible so you can make that decision about whether to self-disclose or not. You can imagine situations where 6 months could be a prompt time, particularly if the conduct was concealed or was limited to a large corporation, limited to a certain business unit. A lot of times, and not to be too kind of cynical about this, we don't know all the facts of this investigation, but you wonder if there was some evidence that was lost or an employee that resigned and went outside the jurisdiction of the subpoena power of the commission that kind of aided that finding or pushed them in the direction of finding that cooperation and self-reporting was not reasonably prompt. I think that would be sort of a more honest standard if it wasn't prompt because certain information was not made available, right? Obviously, it's going to depend on the facts and circumstances.
Yeah. Well, look, let's sum up and bring this to a close. I think big picture, this case touches on a number of significant priority enforcement areas for the commission that are important to keep in mind. Manipulation remains a key enforcement priority, including and specifically cross-market manipulation. Benchmarks. CFTC continues to spotlight activity and key industry benchmarks and will continue to do that. It's very, very focused on physical trading, the physical markets, and the impact that that activity could have on futures and swap markets. And then record keeping for electronic communications with the references to WhatsApp and the failure to promptly produce certain WhatsApp communications. Record keeping is a continued focus of the commission. And then cooperation. What constitutes creditable cooperation continues to be a moving target and in some ways a shrinking target. You should really be putting thought into, as you're responding to a request, how do you want to position yourself with respect to cooperation, and so that if that's important to you in a particular matter, that you have the opportunity to meet the commission's expectations if that's how you choose to proceed. And so I would say each of these areas should be a part of training and for all market participants. So if you haven't updated your training recently, you should always take a look at that. Any other practical takeaways before we wrap up, Brendan?
No, Michael, I think you hit the nail on the head with respect to, as I said at the beginning, kind of the substantive areas that the CFTC is looking at and the more procedural / practice points about cooperation and document collection and preservation. So,
yeah. Well, good. Well, look, of course, you should always consult with internal counsel regarding any potential issues with trading activities in response to regular inquiries to assess risk and determine the most effective approach. So as you make sure your reporting lines are open and as effective as they can be. So with that, we encourage you to take a look at this case and look forward to the next episode. So that's all we have for today. We appreciate you all being with us today and hope you come back to join us for the next episode of the Baker Botts Enforcement Insider. Bye-bye.
Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.